Hello. Hi, sir. Good evening.
Hi, Nikhil. I just logged in through my phone. There was some problem on the device.
Yes, sir. No problem.
I hope that's okay. The video will just be a little blurry, perhaps.
No worries. That's all right, sir.
Yeah.
So, sir, should we start with the session?
Please, yes.
Okay. Good evening, everyone. I am Krishna Lohia, a fourth-year law student from NLUO, and I have with me Shloka Mathur, a third-year student from NLUO and a member at LexTech. We will be hosting the season's episode 2 of TechTales. Welcome to the episode 2 of LexTech, Center for Law, Entrepreneurship and Innovations talk show series, TechTales, from court to courtroom. In this talk show, we invite industry experts from fields like AI, FinTech, TMT, data privacy, online gaming, and much more. This talk show is one of a kind, as NLU is the first national law university to cover these topics in such a format.
The experts we are hosting over a series of multiple episodes will discuss the recent developments in these 5 emerging areas of law and technology. Also, they will deal with the various legal concepts in these areas by explaining the relevant laws and regulations involved. The talk show strives to inculcate curiosity among the viewers in what we at LexTech believe is the future of legal profession. Today's session will be an interactive one where the floor will be opened to the audience in the last 10 minutes.
Yes. Good evening, everyone. Welcome, sir. First of all, thank you so much for agreeing to collaborate with us. I think someone of your stature and your intellect actually agreeing to collaborate with us itself is a very big thing for us. So first of all, thank you so much for that. And for all the viewers, welcome to the second episode of our talk show Tech Tales from Court to Courtroom, where we sort of attempt to call legal luminaries and legal visionaries in these industry fields. Basically, we deal with essentially 5 fields: FinTech, AI and law, data privacy, online gaming and data protection, and TMT as well. So with this talk show, what we strive to achieve is more of information dispersal and sort of educating both the student body at NLU and outside as well of the recent developments in these emerging areas of law. I think sir would agree that many law firms have in fact started actually new practice areas around this around these areas of law, and it's called disruptive technology, if people would have heard of it. So yes, sir, thank you so much for collaborating with us. Good evening and welcome to the show. If you would
Good
like
evening. Yeah,
Yes.
Good evening, Nikhil. Thanks for inviting me, and it's a pleasure to be here. Thanks to all of you, Nikhil, Shloka, Krishna, and I look forward to the session, frankly.
Thank you so much, sir. Just for everyone's, just for all the guests' information, I'll just give it a brief back. I'll just introduce stuff for all of you, and then we can start with the session. So, having graduated with a BA LLB honors degree from West Bengal National Law University of Juridical Sciences, NUJS, sir graduated from NUJS in 2008, and then he went on to pursue his PhD from the Fletcher School of Tufts University. As well, again, Dr. Deborshi, sir has also began his career as an associate with S&R Associates, and he has in fact wide experience in this field of data protection and privacy, and we are in fact honored to have him, and we are honored to have you here today, sir. Currently, sir is a counsel at S&R Associates with their regulatory practice area at the New Delhi office. Yes, Krishna, you may go ahead.
Welcome, sir, to the show. In this episode, sir will be covering 4 major topics. Namely, first, we will talk on the implementation of the DPDP Act 2023 and the earlier bills that were proposed before the passing of this act. Second, sir will decode the provisions related to the collections and data collection and transfer of the act. Then, sir will talk about the take of the act on consent, especially with regards to children and people with disability, and then sir will take on how the industry perceives this act. Finally, we will open the floor to the audience to ask questions in the last 10 minutes. So without further delay, let us begin.
Sir, if you don't have anything to add, if there are no preliminary things, then we can just go ahead with the show, sir.
Yeah, let's I look forward to discussion. I don't want to pontificate. Yeah, please go ahead, Nikhil. Thanks. Krishna, Shloka.
Yes, sir. So coming to the first topic of discussion, sir. So this is the first time India will have its own Data Protection Act. So how do you see this act being implemented in the country?
So it seems that the governmental intent to roll this out in terms of proper efficacy, in terms of robust implementation measures in place, seems to be there. You saw the pace at which this law was published in the Gazette, the way it was passed in Parliament, and the presidential assent followed soon after. So yes, definitely the government intends to roll this out. In terms of implementation on an ongoing basis in the future, we'll have to wait and see. There's a lot of sensitization that needs to be done, both among the public as well across industry. A lot of companies are grappling with this issue in particular, even mature companies, those who typically don't deal with the data business, but of course who do collect a lot of personal data, especially consumer-facing businesses, etc. They seem to be suddenly scrambling for the fact that, okay, we have to get in touch with our ML and AI teams to figure out where within our systems personal data has been lodged over the years. And we need to figure out how to get in touch with them. I'm not even talking about an ongoing basis. I think the industry is still poised to wait for clarifications. Of course, the provisions need to be notified first. So the law is not in force yet, right? Going by the noise that has been created across media and even in terms of law firm commentary across the board, it seems that the law is already at play. It isn't. It's almost necessary to point this out. But the law will be enforced soon. It is clearly anticipated, going by the language of the law, going by the way the government has been rolling out these provisions, as well as pursuant to statements issued by the relevant ministry. And of course, more granular rules need to be prescribed and notified. That can happen pursuant to stakeholder consultations, which probably will happen over the next few weeks and months. How extensive that will be, how much of the feedback will actually be accounted for in terms of formulating the rules, we don't know. We'll have to wait and watch. In terms of the actual enforcement of the provisions, I think there will be a lot of learning, Shloka. So the Data Protection Board of India will first be set up, of course, before individuals firstly approach the Data Protection Board with a complaint. They have to go through a mandatory grievance redressal mechanism through the data fiduciaries, right? Those who are processing or taking the decisions behind processing of data, collecting the data. So that also, there might be hiccups there as well. Like this is another thing, another major compliance requirement that companies need to put in force. A lot of entities, online intermediaries, etc., already were required to have a grievance redressal officer. So their transition will be relatively more seamless, but other businesses, other companies who may not have been savvy with this process also need to put this in motion. It's not just enough to appoint someone within your senior personnel as a grievance redressal officer. You also have to roll out the responses to complaints filed by aggrieved data principals, etc., etc. So we'll have to see how that works. In case there is an exhaustion of remedy on this front, then individuals can, of course, approach the Data Protection Board of India, subject to appeal to the TDSAT and the Supreme Court eventually. So there's a long journey ahead, both at the unit level of a complaint, as well as in terms of the wider ecosystem of how this law plays out. Yeah, over to you, Shlok.
Right, so as you mentioned, it's actually a very long journey because right now that these provisions have just been introduced, there is notification also in the act. There is no specific timeline of implementation as to what is the cutoff date or when will the act will be implemented from. So there's a long way from the transition which has to be perceived by the industries and the government both. So, with that, this is not the first time that we are seeing
Yeah.
the bill being introduced, right? So before this, there were previous bills in 2019, 2021, and 2022 where data protection bills were introduced, but they were not yet passed and finalized. So what do you think is the differences, or how is the DPDP Act 2023 better in terms of, or what sort of improvements are there in this particular act as compared to the previous bills introduced in the parliament?
So in terms of substantive improvement, Shloka, I'm not 100% sure of whether there is any change, material change, or even whether for the better or worse, or status quo is maintained to a large extent. What, however, is important is the strategic importance of having rolled this law out in the first place, based on a well thought out strategy, which I agree with, that maybe have a staggered approach to rolling this law out instead of having a very sophisticated and complex law at one go, like the GDPR or even the CCPA, but take a piecemeal approach, agree on some basic principles, have broad frameworks in place, have broad principles being adopted pursuant to global best practices, and then take into account there'll be a lot of learning, there'll be a lot of local requirements, India-specific situations. Every country is different. So we'll customize it as we go along. It sounds like perhaps an ad hoc approach, but I still think it could be a smart move. We'll take it as it comes. You get everyone on board. You speak with industry voices. You figure out the discomfiture faced by relevant companies. Coming back to comparisons with previous iterations of the law, those were good laws. They were well drafted laws. There was a lot of thought behind that. Beginning from the Justice Sri Krishna Committee to the Joint Parliamentary Committee, there were a lot of wise voices pitching in and looking at global best practices and saying this can work, this may not work in India. Keeping in mind, privacy rights of individuals, as well as, keeping a ear to the ground in terms of ease of doing business. But at the same time, there was a lot of opposition. So there's no point thinking about a progressive regime if you cannot land it in the first place. You have to have, the democratic backlash and the democratic receipt of a law in mind, right? That's how a country functions. So perhaps from that point of view, this was the only option, right? We've been down this journey, as you rightly pointed out, for a long time. Ever since the Puttaswamy judgment in 2017, the government has been trying to roll this law out, pursue discussions. Finally, we're here. The journey is just about to begin. It's nowhere near completion, right? And we'll see how this regime plays out.
Right, sir. So with that, over to Krishna. She'll be taking the next part of the discussion.
Sure.
Sir, so in the second part, we will mainly deal about how the Act takes on data collection and transfer. So my first question is, are there any specific rights of data principals that data fiduciary must be aware of while performing his duty, like the liability and obligations of data fiduciary to respond to the request of the data principal, given the Act lacks a specific time frame within which such requests are entertained?
No, so Krishna, thanks for that. So let's take that question one at a time, like different parts of the question. The timing issue is something else. Okay, let's talk about that separately.
Right.
But I mean, that will play out the way it needs to, right?
Right.
The government has retained a lot of powers with itself, and the government will notify the provisions and frame the rules in due course. Looks like there'll be a 6 to 8 month, maybe a 10-month period, by which time the industry players, the stakeholders need to transition, need to align their respective business operations. So in terms of the obligations of data fiduciaries on the one hand and the rights of data principals on the other hand, right? So data principals are people like you or I, actual users of services, etc., the individuals to whom the data relates. They were called data subjects under the GDPR of the European Union. And the data fiduciaries are those who are taking the decisions behind processing and collection of data. Of course, they can ultimately outsource a lot of activities based on that data collected to data processors pursuant to contracts or otherwise. There are some requirements whereby you have to get into a contract with the data processor if you're offering services or goods to people in India. But otherwise, if there is something else, it can be done through some other bespoke arrangement between the data fiduciary and the data processor, respectively. So the data principal rights are closely aligned with the obligations of data fiduciary. For example, if the data principal has a right to not have her data collected without her consent, for example, in some situations, which are not legitimate uses, which gives the ground for non-consensual data processing as well. Correspondingly, and at the same time, the data fiduciary also has the obligation to request for consent along with a notice giving prescribed informational heads about what the data is for, what data is being collected, how they can instrumentalize a grievance redressal mechanism, who to get in touch with in case they have a complaint, etc., etc. So they go hand in hand, right? And the data fiduciary, over and above whatever has been laid down in the Act about what their general obligations are in terms of giving notice, requesting for consent, actually taking an explicit consent, then processing in a particular way in terms of having technical and organizational measures, having proper security safeguards, and industry will probably evolve some bespoke standards based on what kind of data is being collected, how much data is being collected, how sensitive the underlying data is, etc., etc. So once that happens, data fiduciaries also have to keep in mind that the data principal rights relate to, for example, them accessing the data. They can request the data fiduciary to say, okay, after upon a time, you let me know what of my data do you have? You give it to me in a specific format. Yeah. And this again closely follows to the trajectory that we have seen in the GDPR, for example. This is the right to access right, so to speak, under the GDPR. So those things are there. So data fiduciaries have to anticipate, what kind of rights data principals have, how they may exercise such rights in the future, and accordingly, design their compliance strategy. So to keep hopping back on the same point that I said before, they really go hand in hand. They're not like standalone regimes, right? The data principal rights stand in isolation in a separate silo, and the data fiduciary obligations are in a parallel universe. They complement each other, and that's the way the Act has been designed.
Thank you so much, sir. Just one second, Krishna. Before we move ahead, sir, for the benefit of the audience, there are a lot of people here who don't know exactly what a data fiduciary is and what a data principal is. So if you could just explain that to us in a very simplified way, just for everyone's benefit.
Absolutely. Thank you so much for that, Nikhil. That's a great point. So let's actually start from, I'll give a quick primer to the extent that I can without wasting your time. And I know a lot of questions are forthcoming. So data has been defined very broadly. Data and information are typically used as very synonymously in most data protection laws across the world, right? So when we say data as opposed to information, although under the previous regime that we had, which still exists, by the way, in India, under Section 43A of the Information Technology Act of 2000, which was amended in 2008, where Section 43A was specifically included, which talks about, protecting especially sensitive personal data or information. That is a formulation in the Act, and the rules that were framed thereunder in 2011, which are, it's a long name, so we, acronymize it to the SPDI RSPP rules. RSPPs mean reasonable security procedures and protocols. SPDI means, as I said, sensitive personal data or information. So there was a lot of guidance, and companies came to law firms and figured these things out themselves when they were dealing with arguably sensitive personal data or information. Here, personal data, or sorry, rather personal information was defined. So it's not like personal data, we borrowed this definition completely from the GDPR afresh when we have this DPDP Act right now. We had some awareness. Personal data under this act, as well as in previous iterations of this law, means data which relates to a specific identified individual, right? So, if you start unpacking this definition, as simple and rudimentary as it seems, there are a few elements which we don't need to get into right now because that will take time. That's a separate discussion itself. But personal data is not as narrow as it seems at first blush. And this needs to be kept in mind. And that's what we've been telling companies as well. And this is relevant because they have to figure out there's a lot of commercial and non-personal data that companies have in their systems intermingled with personal data. What is personal data? Is a company name personal data? No. How much my private information, my name, my phone number, my email address is very obviously personal data. But what if there is some other element, other piece of information that a company has, a data fiduciary has, which coupled with some other identifying elements will constitute together and cumulatively personal data. So that also needs to be seen. And data fiduciary is an entity. It can be any entity. It can be an individual. It can be a company. It can be a firm. It can be the government itself. It can be any artificial juristic person, which basically collects data and ultimately takes a decision to process that data in a particular way. So for example, if I'm collecting your data or I assign someone else to collect your data on my behalf, that third party will actually be the data processor, even though that entity may have the first interface with you as a consumer, or as we call the data principal. The data principal are individuals like you and I. Data principals cannot be companies. Data principals will only be individuals, natural persons, as the GDPR says, right? Human individuals. And the data fiduciary will take the decision about what to do with the data, right? That's basically it in a very broad, sweeping stroke.
Thank you so much, sir.
Also, as you stated, that the Act takes care of the rights of data principals' right to access. So, does the Act simultaneously take care of right to be forgotten of the data principals? Because
yeah. Sorry, go on.
Because a lot has been debated about right to be forgotten when it comes to data online, especially digital data.
Right. So there's a right to get data erased. A right to be forgotten is a mixed bag. So I think what will be best is not to borrow the European vocabulary in this context, because we've been socialized to thinking about personal data based on the European template, right? Because GDPR has spawned all these data protection regimes, whether in Brazil, in India now, or even in the US context. The federal statute in the US is also in operation. I mean, is being worked out. The right to be forgotten means, simply put, that if you have my data already, I can get in touch with you, whoever has my data, and say, okay, you get rid of my data. I don't want you to have my data anymore. So if you think about it in such a broad, simplistic way, we have something like that, right? Under the DPDP Act of 2023 in India, where if a business has my data, I have consented to the use of my data in a very specific context, right? What has been defined specifically as a specified purpose under the DPDP Act. And I say that, okay, say, for example, if I'm giving my data to you for the purpose of helping me find a job, you cannot use my data to give me targeted advertising in terms of, florists in my neighborhood because I want to buy flowers. Just because you have inserted cookies into my system and you figure out, I have a love of nature or something like that. That is not permitted, right? If I figure out that you've, distributed my data whether through monetization schemes or otherwise. And this is not something I've given my consent for. So I can fine tune and tailor to what purposes you can use my data for. That is at least the understanding. That is the objective. On the other hand, if 5 days later, 5 months later, I change my mind about, okay, listen, I still am unemployed. I haven't got a job. Obviously, the data, all the data that I provided you with about me has been useless. So I want you to get rid of my data. So I can, through a mechanism which would be prescribed perhaps in more specific terms under the Act, I can request you to erase my data. And I say that I withdraw my consent previously given. At that point of time, that platform needs to get rid of my data. So this is akin to a right to be forgotten, right? And also the data fiduciary concerned here needs to get in touch with all the respective data processors and within a reasonable amount of time ensure that all these platforms get rid of my personal data, which has been previously provided by me pursuant to my consent. So yeah, in a nutshell, this is it, Krishna.
Sir, so again,
Yes,
thank you for that answer. But again, this is with the context of say businesses. If say an app, say like Zomato has a bit of my personal information for
Right.
the purposes of me ordering, say, a pizza. So
Right.
that's all right. But I think the major debate in the industry even today is what about the government that takes our data, and where is our right to be forgotten with respect to the government? Because again, I mean, India is no foreigner to this particular aspect, because even during the Aadhaar card,
Right.
when it came in, there was a lot of petitions filed, and there was a lot of debate again as well as to how much access and for how long access can the government have to our data. So in terms
Right.
of that perspective, how does this new act sort of protect our rights from the government itself?
Right. Right. No, thanks for that question, Nikhil. This has obviously been a burning issue. A lot has been spoken about and discussed and debated in the wider media about the government rights. Like I said before, at the beginning of this session, the government has deliberately, by design, retained a lot of powers with itself, both in terms of being insulated from a legal liability, um, you know, immunity from legal proceedings, the power to call for information from a wide variety of entities, not just data fiduciaries, but other intermediaries, which could include data processors also. Um, the government ultimately has the power to appoint the techno-legal experts on the Data Protection Board of India. They will have the power to issue directions. They will have the power to frame these rules, not through delegated legislation to a regulatory body. It's not like the DPBI, through a step-down process, will be framing the rules. It's the central government which should be framing the rules, whichever the nodal ministry is. It looks likely that it'll be the Ministry of Electronics and Information Technology, but in the future, it could be something else. So by design, I think the fact that this law is being rolled out for the first time in India, and keeping in mind the institutional maturity, the level of awareness among the public about things like privacy, about informational security, etc., the government found it necessary to retain a lot of the powers with itself. Think about it practically as well. I don't mean to be talking from an idealistic point of view, not that idealism is bad, but it's a government framing the law, passing this law. So the government will, in the context of any law across countries, across histories, across geographies, across epochs, it's a story of humanity that the government will retain a lot of the powers with itself, right? What is the incentive to do otherwise? Also, the government has a lot of plans in the future about doing stuff with data. Europe has a very efficient and ambitious data governance, trajectory lined up. It is almost inevitable, given data is so vitally important these days, not just because of machine learning or artificial intelligence purposes, but the way the businesses are designed, the way our personal information has become so valuable, and we are deeply aware of this now. So the government wants to have a lot of extra powers, not just in terms of, the official statements given by governmental representatives about, what if we want to give subsidies to people, what if there is an epidemic and we vitally need information about, individuals. Of course, that no one's debating that. That's a bit of a squirreling tactic that again officials do. But other than that, what may not be out in the public domain, which may not be articulated, which would still make sense, strategic sense, is that the government needs to keep a lot of the powers. How it will actually be exercised, whether, I mean, there is potential for abuse, for sure. But whether it'll actually be abused or not, we don't know. How activist the courts will be eventually, if something goes up to the Supreme Court, for example, in this matter, given that there's a lot of insulation from legal proceedings that the government has figured out for itself. Let's see. Maybe there will be challenges about some of the government powers in the future. I don't know.
It might end up being another UAPA story. So.
I doubt
think
though
that's something we have to
whether
see
the
again.
constitutional challenges or anything else will pass muster eventually. But I'm just saying it's possible. Yeah.
Thank you, sir.
Nikhil.
So, sir, we have talked a lot about free-flowing data and everything. So, if we talk about cross-border data transfer provisions provided in the Act
Right.
follows the blacklist mechanism as compared to 2022 bill that provided for whitelist mechanism.
Right.
How do you think that would help in easing of business internationally for India?
So just for the benefit of others, Krishna, the whitelisting approach that you're talking about means that, unless expressly approved, you cannot transfer data to a particular country or territory. So for example, if there's data in India, localized, if you have to transfer data to a country X or a territory Y in the world, you have to check whether it has been allowed by the Indian government, right? Otherwise, you cannot transfer data. That is the whitelisting approach. It's obviously more onerous. Free flow data flow, cross-border data flows will be limited. You have to wait and watch, take it one step at a time, blah, blah. As opposed to the blacklisting approach, which has now, as you rightly pointed out, been adopted in the 23 Act, is that unless, Joe, you can transfer data to different countries and territories across the world freely, without taking consent, without figuring out whether it is allowed or not, unless and until it has been expressly prohibited by the central government, which is also required to be pursuant to parliamentary tabling. So it's not like the central government can issue a notification just by itself saying that, okay, you cannot transfer data to Myanmar, you cannot transfer data to Venezuela because we think the political climate there is unstable, for example, and data belonging to arguably Indians may be leaked, and then there may be a lot of harm caused. Whether this comes from a place of looking out for Indians and their interests, you cannot do this by yourself. It has to be pursuant to parliamentary approval. So that much of a safeguard is there. At the same time, this is obviously very business friendly. So a lot of data processing arrangements are already in place between Indian entities and foreign entities, which have a historical relationship of processing the data in India, where these technologies, labor, etc., is cheap. So it makes sense for foreign companies to transfer the data to India, get the data processed in whichever way possible, and even have an ongoing relationship in terms of, say, storage or keeping tabs on employee information, etc. Get analytical insights on the data transferred from a US entity to India, and then have the data transferred back to the US, for example. So if you have to do that, because the US, for example, has not been expressly prohibited as one of the blacklisted countries under the blacklisting approach, you can do that without going back to the government saying, petitioning the government, requesting the government for a special approval. Yeah. So yes, as it is as fairly intuitive as is very clear, the blacklisting approach is more business friendly. Yeah.
That said, sir, how do the Act take care of any breaches that might take place in this free-flowing data environment?
Yeah. So that's always a concern. So in terms of, if you look at the provisions on exemptions under the DPDP Act, a number of exemptions have been granted to the government, for example, or those entities which have been specifically notified by the government to have been exempted based on parameters which are yet to be prescribed, or based on indicative parameters which may be expanded upon and subject to governmental discretion, be granted to individual data fiduciaries or classes of data fiduciaries, whatever, or say startups, for example. But if you look at the language of exemptions, even when certain entities may be exempt from a lot of the provisions of the DPDP Act, they will still be obliged to undertake reasonable security procedures. So it's not possible that just because you have someone's personal data and you appear to be exempt from the DPDP Act, you can do what you want with that personal data. And in case there is a data leak which causes, loss to someone else, then, you will be completely insulated from liability. How this jurisprudence develops in the future, we don't know. But there is still a certain amount of threshold responsibility and therefore potential liability in the future. In Europe, because of these concerns, of course, the European regime for cross-border data flows is more stringent. That is closer to the whitelisting approach as we had before, like you said, in the 22 draft of the DPDP Act. We have moved away from that, and this is a more liberal approach that we have relative to the GDPR. But what did evolve in Europe is, these binding corporate rules, or SCCs, or standard contractual clauses. So the supervisory authority under the GDPR will take a call on which countries and jurisdictions have adequate data protection regimes. So if they figure out that India has an adequate and robust data protection regime, then they may allow data to be transferred to India without specific requirements. But on the other hand, entities themselves may have standard contractual clauses whereby they can transfer the data subject to certain customized templates which have evolved over time. So in India too, it is highly likely that we will get to this sort of a regime whereby we have bespoke contractual provisions whereby there will be an obligation for the recipient entity to take care of the data in a particular way, which is compliant with our expectations under the Indian legislative mandate. So it's not like just because we transfer the data to, say, someplace in Latin America, Europe, Australia, and there is a massive data leak there, and Indians' data is spread out there, it'll be without recourse. So something might evolve in the future. There is a concern. I hear your point, but there are fixes around that.
That makes a lot of sense, sir. So the third part of the session will be taken up by Shloka. Shloka.
Thanks, Krishna.
Thank you, Krishna. So moving ahead, like whenever any legislation is legislated, so there's very important aspect where every legislation focuses on, which is the rights and protecting minors, like children. So they are the vulnerable and sensitive part of the community and the stakeholders. So, sir, on that note, how is this DPDP Act protecting the rights and the personal data of children, which are being taken up by the industries? For example, the EdTech platforms, the online gaming platforms. So in that aspect, how are the children being protected?
So again, for the benefit of others on this talk who may not be aware, although it has been so widely written about that I think everyone seems to be in the know. So unlike the CCPA, the California Consumer Protection Act in the US, because in the US there is no federal statute yet, as well as in the GDPR, the age threshold for defining a child and therefore having additional or special obligations to process children's data is much higher in India. And this seems to be and seems to have continued to be a governmental priority. So under the Digital Personal Data Protection Act of 2023 in India, that age is 18. So if you're a 17-year-old person, individual, you will be considered to be a child under the DPDP Act. So under the CCPA in the US, it is 13. Under GDPR in Europe, it is 16. with the ability of individual member countries of the European Union to decrease that age to 13 even. 18 obviously seems to be an outlier in terms of this age threshold. So from that perspective, Shloka, to come back to your question, seems like DPDP is a lot about protecting children's data. If you look at the specific provision on the special obligations that data fiduciaries have about children's data, you are prohibited from undertaking targeted advertising, behavioral monitoring, stuff like that. You also cannot take any measure which causes some detrimental effect on the well-being of that said individual. Having said that, since you mentioned edtech platforms in particular and online gaming platforms, it could even include to schools, for example, or hospitals which have children's data. Like, people under 18 do get sick, right? And they do get admitted to hospitals often, and you have to have that vital data, which is unequivocally sensitive. For example, their medical history, some genetic condition, etc., etc. This is, sensitive data 101. So what happens is, if a particular entity is able to demonstrate that the processing of data that they undertake is safe, then the central government may exempt them from some obligations to the extent that they can lower this age of 18 to, I don't know what it could be. It could be 16, could be 15 or whatever, whereby until the age of, say, if it is lowered to the age of 13, just hypothetical case I'm saying, for a particular data fiduciary, okay, for an edtech platform, say. So they say that, okay, there's no point having, a very high age, 13 makes sense. For an individual under the age of 13, you have to take parental consent in whatever mechanism does evolve. But above that age, that individual can take a call about what data they are providing to an edtech platform, for example, because they want to take a special course. They want to learn coding. And there they say that, a lot of parental consent is required, which is impeding her progress, her ability to undertake knowledge and training. So in that situation, what will happen is, for any individual who is above the age of 13, they don't have to go to their parents or lawful guardians to take consent each time. So that'll be the net result of lowering this age, but which will, obviously depend upon governmental discretion based on parameters that evolve over time. Broadly, we know that you have to be able to demonstrate that your processing activities are safe for the government to get comfort. So this definitely seems like a beacon of hope for edtech platforms, for gaming platforms, etc. Yeah.
Yes, sir. So, like, when we talk about the current times where the children are actually exposed and we say this Gen Z world and all. So, sir, in that scenario, like when we talk about the penalties which are mentioned in the DPDP Act, so for example, if there's a breach of data of a particular child or if there's a breach of data of an individual and adult, so do you think that the penalties which are there in the Act, are they different or the same, or the liability should be more in case if a sensitive stakeholder like a child is involved?
Yeah, I mean, there's a certain amount of deterrence that the government has tried to design, right? So there's a separate financial penalty for, breaching the special obligations attributable for children's data, for example. So that is just to keep in mind that, data fiduciaries take the additional or special obligations for processing children's data seriously. Also, if you think about it, other than vague subjective things like to ensure that your processing activity involving children's data does not does not prove detrimental to the well-being of a child, which is subjective. On the other hand, there is a logistical requirement of taking parental consent. These kind of make sense. On the other hand, you have something like, which actually has a lot of teeth, which will actually have a lot of commercial implications, is that you cannot undertake target advertising or behavioral monitoring. Like, children are big consumers. They are a huge target audience for a lot of platforms, including platforms which cater to adults as well. Children often drive their parental purchase decisions, which is why a lot of ads that we see on TV, there's a kid who's saying, okay, this toothpaste is damn good, or this juice is really tasty, or if I have Complan, I'll be very strong. Why do we use children, right? It's at a very psychological level to invoke parental emotion, etc., etc. Long story short, children are often also the target audience. For example, the toy industry, children are often much more technology savvy than their parents, for example, and they are, I mean, I don't even think it's an arguable point. It's obviously a no-brainer that they consume digital platforms much more than their parents do, and this will only increase over time. So it almost sounds paradoxical that you have age gating thoughts for children in particular. I obviously, it makes sense for a 5-year-old. We already have restrictions in place for harmful content, for, I don't know, for violence, for sexually explicit content, for pornography, etc., etc. Obviously, you need to take care and protect children. But in terms of other platforms, social media platforms, digital technologies, which are more generalist in their content and reach and scope, but at the same time, I think there's a certain amount of learning again that will happen over time, and platforms will evolve where a parental consent will be registered with either an e-locker, something like a digi-locker or something, where transaction will become more seamless over the future. So the fact, however, that from a mass of data that you have, one of them could be a child. You have to have a mechanism in place where you need to be able to establish for your internal compliance purposes that this person is a child. Therefore, I have additional obligations. So if I have some algorithm in place which is tracking their data, I have to ensure that that individual's data is not tracked. So I have to have these technical fixes in place, because otherwise the liability is there. It's all right for me to track that child's mother's data because both of them are using it, but I can't track that child's data. I cannot have target advertising given to this child. So the next time the child accesses my platform, you cannot show, like, I don't know, some new video game ad, because that is prohibited. At the same time, if the mother logs on, you can have that ad streaming on her device or screen. Yeah. So these are the considerations that companies, firms need to figure out.
Yes, I completely agree. I think that extra compliance with respect to children is actually very necessary because of them being sensitive and the driving force behind a lot of consumption of data on the internet.
Right, right.
Yes, sir. So moving ahead, like you mentioned about consent here in the case of children, like the consent of the parents necessary in terms of this data processing of the data. So with the DPDP Act, there's a mention of a requirement where disabled people are supposed to have the consent of their guardian. So why do you think that this was introduced, and what was basically the requirement of such a clause where a disabled person needs to have the consent of his or her guardian?
So thanks for that question, Shloka. It depends upon how disabled is defined under the DPDP Act. We have definitions in place, and the disability legislations we already have. The thinking behind this, disabled persons were not included in the same category as special provisions, special data principles like children in the 22 version of the draft. But now we have. I think the thinking is to protect individuals who may be, perhaps, to the extent that you can talk about these things, a higher level of disability whereby they cannot, they are more susceptible to manipulation by motivated entities or persons to steal their data, to cause them harm, etc., etc. So I think it's just supposed to have a check and balance thing in place, whereby if a person is disabled, you have to take a high level of consent, whereby the lawful guardian will also have to come in. What if that disabled person does not have a lawful guardian? I don't know what's going to happen. We'll have to see. Logistically, practically speaking, how do you check for disability? If I have an online platform and an individual comes trying to access data, and then I ask for that person's data and the person gives consent individually without invoking anyone else, and it turns out that the person is disabled, whichever way disability is defined in the future, how do I check for that? So these processes need to be rolled out also. So some of these rules may also give clarity. Some of the new rules that will evolve and be formulated will probably give clarity about these things. And to have to implement them, data fiduciaries also have to have processes in place to figure these things out.
So when I read this provision, I think my sense of it was that the government's intention is more from a precautionary standpoint, in
Right.
the sense that it's just to protect these so-called whoever they've defined as disabled people, because I don't think it's defined in the act as well. So I think, as you said, more clarity on that will definitely help in figuring it out.
Right. I agree with you, Nikhil, completely.
Thank you, sir.
The protection, I think, is the touchstone of having it include this class of individuals or persons.
Yes, sir. Thank you.
Yes, so as Nikhil also added, so I think in that case, both data fiduciary and the disabled, which they've mentioned, we need more clarity on that as to what sort of parameters would be there and what would be the process. So for that, I think we need more rules in that aspect.
Yeah, absolutely.
Right, sir. Thank you so much, sir. So Krishna would be taking forward with the industry take on the DBDP Act. Krishna.
Thanks.
Sir, I think so. DPDP Act is one amongst the act which was most awaited also, but most dreaded also by the industries. So how do you think the e-commerce social media platforms who literally thrive on excessive data collecting algorithms will react to the act, given that it makes all the necessary data collected by them outside the purview of consent?
Right. So Krishna, thanks for that. And that's obviously a very important question. I would just like to add, and something I hinted at before as well, it's not even these e-commerce platforms or social media platforms, etc., which very obviously have a large amount of data, and their business model relies on data collection and processing. But a large number of other companies as well have a huge amount of data, some of which also includes personal data, right? So the compliance obligations will definitely increase across the board for all companies, almost all companies, right? More so for certain kinds of companies, depending upon their business, right? The law anticipates a specific category of data fiduciary called a significant data fiduciary, which again will not be notified upfront. The government will take this call based on certain prescribed parameters, like the amount of data an entity collects, the sensitivity of the data, whether there's some national or public interest involved, etc., how much it can affect the rights of data principals, etc., etc. So it's very clear that some of these online platforms are more likely to be notified as significant data fiduciaries. They have additional obligations. They have to undertake periodic data protection impact assessments. Again, something that we have seen under the GDPR. They have to undertake periodic audits. They have to have a data protection officer who is based in India. And there may be additional obligations which may evolve over time. So not all companies will be notified or are likely to be notified as significant data fiduciaries, but most companies, if not all companies, for example, will be data fiduciaries because they are handling ultimately some kind of personal data. So they have to be in compliance. So they have to check for whether they actually fit that bill. and then they have to check for compliances. We have a 6 to 8 month window before the act becomes effective. They, of course, they have to wait for further clarity, which might come through rules, but at the same time, they need to start preparing. I mean, you can't redesign your processes overnight and hope to be in compliance. To come back to something that you were asking before, Krishna, in terms of the timelines have deliberately been kept vague. So I'm not just talking about by when this act will actually become effective along with its rules, but different provisions of the act may be notified at different points of time. So something that we saw, for example, in the Competition Act or the Companies Act of 2013, where different provisions were notified from time to time. Not all of the act came in effect at the same time. Something like that might happen here as well. It is deliberately been budgeted for by the government. On the other hand, companies need to figure out, first, do an extensive data mapping. They have to go back to their legacy databases. They have to get in touch with relevant teams, their IT infrastructure providers, their homegrown and their on the payroll IT experts, and figure out a process, a quick process, an efficient process to figure out where data is lodged, which of that data is personal data, and the first thing they need to do is, where consent may have been provided by such individuals before the act comes into force, they have to send notices out to such individuals after the act becomes effective. They don't necessarily need to wait for their consent, but they need to, in that notice, the exact format of which will be prescribed later, but they have to tell them what data of these individuals they have, what they do with the data, whom have they shared the data with in the past, etc. Then, unless the consent is withdrawn by said individuals, they can continue processing the data, whether it just means storage or using or sharing with other entities. So this is the first obligation. On an ongoing basis, they have to give notice, they have to request for consent, they have to actually take consent in the prescribed ways, and process data in specific and limited ways in the future, right, as the act requires. So for that, they might want to develop their internal systems or outsource some of these consent management functions, which they need to have in place to third parties through customized arrangements, right? Whether by contract, if required, or even if not required, or otherwise. So coming back to something else we were talking about, Krishna, about the data principal rights, right? So individuals may suddenly come back to you and say, okay, listen, I've consented to all my data. I now want to know what of my data you have, whom have you shared it with, or I want to withdraw my consent right now, okay? So you have to have a process in place to immediately respond to such requests. So you have to have some kind of machine readable format which you can provide to the requesting data principal and provide all the details as sought. Now the act already gives you an indicative idea of what kind of information may be sought by an individual. So you can start designing your systems and processes right now. You can start thinking about it. Absent further clarity about what heads the data principal can ask for in terms of informational categories, you can add layers to it. If consent withdrawal is permitted, which it is, then you also have to figure out a quick way to erase said data from your database, right? So in that respect, if you have an arrangement with a third party, whether at the data processor level or in terms of another data fiduciary whom you transfer data to, you being the first point of contact with an individual, you have to figure out that they also erase that data, right? So in that respect, you have to have a way to track, okay, within an expansive database, which may have like thousands of people's data, right? Who has who has withdrawn their consent, who hasn't? So you can't reproduce the same database and recycle it on and on and on, right? You have to have a tracking mechanism whereby as soon as someone has withdrawn their consent, you purge that person's data from your database. So these systems need to be designed. Also, in terms of compliance, there are multilingual obligations. 22 languages under the 8th schedule of the Indian Constitution. Notices have to be provided under if requested for by data principal. So this may also be both a logistical / technical / technological plus a cost factor that you need to budget for as a data fiduciary, as a company. So this also needs to be planned for.
Sir, I think the debate, or I wouldn't call it a debate, the considerations would be mostly industry specific, according to me. I mean, that's the sense I got of it. So, for example, when you spoke about who would be, which company would be classified as your data fiduciary, you said that most companies would, in fact, have higher compliances to match up with. So I think it'll depend on the industry itself that that company operates in as to what exactly that data is being used for. Say, for example, if it's a food and beverage company like that's selling food, say Zomato or Swiggy, the type and the type of personal data that that company has and the level of data protection that that type of data requires is different from, say, something like medical data that, say, a hospital or a practice or any digital doctor consultation apps that are coming up nowadays have. So maybe that way the government can sort of think of it as they can apply an industry specific approach. So similar to say what the SEBI does, gets a consultation paper out, consults with stakeholders and then finalizes. I think that would be a better approach according to me.
Yeah, no, I absolutely agree with you, Nikhil. So for example, if you look at it from a general point of view, something we spoke about again before, that the fact that it seems that the government has been adopting or wanted to adopt a piecemeal approach and take into account a dynamic learning, So firstly that, do a little bit of trial and error thing. So instead of putting all your cards on the table at one go, before you realize, the consequences, you take a piecemeal approach, go step by step. On the other hand, in terms of diversity of businesses, as you rightly pointed out, for example, some information, some industries may deal with more sensitive data. So in that respect, for example, the SPDI rules under the IT Act at least recommended certain industry standards, right, in terms of information security, like ISO 27001, for example. But nothing has been explicitly prescribed or recommended under DPDP Act. Something may come up in the rules. But again, like you said, even in the rules, it may be industry specific and not, one size fits all kind of a thing, where hospitals may be required to undertake a higher level of protections, technical measures in place. Some new standards may evolve. And like you said, more consumer retail outlets, fast fashion, food, more consumer electronics, they may not have more as stringent requirements. Right. I think this makes sense. I agree with this approach as well. And I agree with your analysis of it. Yeah.
Thank you so much.
Yeah.
So that totally makes sense. And sir, we may hope to see a future when these companies like Zomato and Myntra's notifications slow down actually.
Yeah. I think that is something that going by governmental statements, and when I say governmental statements, I don't mean press releases necessarily, but say, for example, formal interviews which, say, ministers of MeToo may have given to different press bodies, etc., or newspapers. It seems they have often mentioned stuff like this. Suddenly I go to a platform and I see a random ad based on my past activity. So there are cookies in place. Sometimes they are third-party cookies which are tracking my data. They are persistent identifiers. So say, for example, if I'm logged in through my Gmail account on Google, any other site that I visit, one centralized repository will keep track of all my interests across a plethora of activities. So, and that's exactly how, I mean, until a few years back, we would often wonder how, if I'm logging into a platform, suddenly they showed me an ad for a fridge when I just ordered for a fridge yesterday. Like, how on earth do you know? So obviously there's a system in place. It's not rocket science. Now, of course, there's a lot of awareness about it, other than obviously a lot of irritation. But just to balance this out and play the devil's advocate, um, processing a lot of essential information, as well as keeping track of a wide variety of consumer interests, is required to a large extent in a capitalist economy, especially. So it also helps us, right, to have our customized preferences in one place. It makes our use of that particular interface more convenient, more seamless. Of course, where do you draw the line? How do you draw the line about what is irritating and what is convenient, right? That is subjective and that is a dynamic thing. So, which is why I think they try to relegate this to the realm of consent. So if I'm getting too irritated by these constant pop-up ads or something, I can withdraw my consent. I can unsubscribe from a service. I can whatever, take other measures as implemented. Yeah.
Nowadays, algorithms are like, if I think of a pizza, I get a 20% discount from, say, Oven Story, like instantly.
Right. Absolutely. Sometimes when I talk about, something I want to buy with a group of friends, I sometimes switch my phone off because I immediately think that my phone is always listening, because all these things that I don't even understand are in my phone and they are listening in. And as soon as I log into some other platform, they will give me a pop-up ad or something. Okay, recommends this, recommends that. So yeah.
So how do you think the fintech industry will perceive this app?
Because I think, sir, especially with the recent developments and the digital lending guidelines that came out last month,
Right.
and the recent FLDG framework that was implemented, I think data privacy concerns, especially when it comes to financial data,
Right.
given the fact that India has been getting a lot of FDI and most of it is for fintech companies. So in that sense, I think financial information's protection is pretty important as well.
So even last month's court's judgment on PayPal also.
Right. No, for sure. So obviously, like you rightly pointed out, financial information is more critical, is more sensitive, even if it is not defined as such in the act. But it's, it when you see it, kind of a test. Obviously, my financial data is very important to me and important to others who am I sharing it with or having to share it with for say particular transaction or because of a legal requirement. So to that extent, it's a no-brainer that given that fintech companies were also following this legislative trajectory, and they knew that it would hit them sometime or the other, right? Some bespoke sector-specific requirements were already in place, so it's not like they're unused to it. There was a lot of expectation around it, so the amount of planning and thinking behind compliance strategies about personal data protection, I think the fintech entities were ahead of the game relative to other entities. Of course, the others like e-commerce platforms, social media platforms, other online intermediaries were also deeply aware because that is part of their business. But I think the sector-specific requirements for fintech entities will also evolve in parallel with the DPDP Act. So while the DPDP Act gives a threshold, a basic minimum, that this is what you absolutely need to do, doesn't matter which sector you belong to, as long as you're dealing with personal data. Over and above, depending upon your industry, depending upon what kind of data, sensitivity of the data, volume of data, financial data, you have to have other measures in place, which is not in derogation of the DPDP Act, but which are more specific and require higher obligations. For example, there may be data localization norms. You might have to have more customized arrangements with data processors. We have seen some of this already for payment system providers, etc. Having said that, there are some exemptions in the DPDP Act which make it clear that some of these exemptions will apply, at least at this level. For example, if you have to collect and/or process personal data which relates to figuring out the financial information of a person or her assets and liabilities, if that person has already defaulted on a loan taken, has failed to repay, or if there's a merger and acquisition transaction, or some kind of corporate restructuring which is pursuant to a court-approved mechanism or other regulatory or point of authority. In this situation, there may be broad exemptions available in handling personal data. So again, this I think goes back to the interests of the economy, interests of the financial sector, interests of, like you said, like Nikhil was talking about in terms of FDI. You don't want to be known as a restrictive regime which has a lot of these obligations in play, which becomes a major headache for corporate entities to do business in, or in terms of making acquisitions, etc. So I think they've thought about it. Some more exemptions may come in, depending upon, okay, you know what, for example, in some kinds of transactions, commercial transactions, we might realize that, okay, the fact that you have to collect a critical amount of personal data, take their consent, is becoming a huge impediment. And something else might evolve, for example. Like in terms of actual transactions, in the recent past, there was some onboarding that was happening. There are some companies which already provide analytic insights, okay, in terms of logistics, etc. So there's a platform which is already in existence, and they have a lot of data. So their client uploads their data, and they benefit from the use of this platform by figuring out what other entities across the supply chain are doing. And there's an investment being contemplated by a major entity into this platform. And part of the deal is that we want to have access to some of this data, because this will help us to design our systems, our customized systems better as well. While most of this data is commercial data, but a bit of it is personal data as well. So the companies concerned which are negotiating this deal are worried about, okay, which of this data is personal data? And if it is personal data, to the extent that we have not taken consent, do we need to take consent in the future? Yes, you have to. At which level do you take? Because like I explained in this situation, it's happening at various levels. It's happening at a platform level. It's happening at an entity level. It's happening at a corporate level in terms of the investment being made. So which of these entities at which time needs to take consent from which individual? This needs to be figured out, right? So these are things that entities are beginning to think about, which we never thought about before, right? In India, Europe woke up to this reality around 2016, once they realized that the previous directive was going to be given more teeth to. GDPR did not emerge out of the sky, right? There was a precedent legislation even in Europe. The data protection directive, which was in place since the mid-1990s, already had a lot of the GDPR-like provisions in place, except it was not implemented very well. But since 2016 or before, a few years before that, ever since it was likely that the GDPR was something like the GDPR was about to emerge, entities started thinking about these things. So I think this is part of the thing. It's like it has cultural, symbolic elements as well. This law, if one were to get poetic and academic about this. So entities need to start thinking about data differently. We can't take these things for granted. As soon as personal data is involved, you have to have your thinking cap on and figure out that, okay, privacy is a thing. Individuals may not want that data to be shared. Individuals still don't have too much of an ability to monetize their own data. something like that might emerge in the future. Let's see. But at the same time, they can take control of that data. And that is something that the government, I think, wanted to do.
Yes, sir. Thank you so much. I think a lot has been spoken about since the past 45 minutes about the new act. And I think, sir, I agree with you. The vision of the government, I think, first coming from the judicial decision of K. Puttaswamy, the right to privacy being declared in 2017 as a fundamental right. From there, the roadmap in 2023, today we have our own Digital Personal Data Protection Act. I think that road has definitely not been a smooth one. There have been a lot of changes, a lot of drafts that have come in. But I think definitely from my perspective, at least, this act does have a lot of improvements, and it definitely will. The pros and cons of it have to be again evaluated once it is actually implemented. But I think we're at a stage where we have something that is good to go, and we just need to see how that will be implemented well, I guess.
Yeah, in a nutshell, this is it, actually. It's good to go. It's a starting point. We needed this. Something is better than nothing. It's not that bad, this law. It could be very good. Let's see how rules come and how it's implemented.
Yes, sir. With that, I think we come to the end of this session. So if now we'll be opening the floor for the audience for the next 10 minutes, if there are any questions. So I would request everyone to quite kindly raise their hands, and we will be allowing you one by one to ask a question to sir for the sake of convenience. Yeah, thanks.
Yeah, thanks, Nikhil.
Yes, Yashunandini. So this is Yashunandini. She has.
Hi.
Good evening, sir.
Good evening.
I'm so sorry I cannot open my camera right now.
No, that's fine.
It's a little sketchy, the camera, so yeah. Thank you. So I know you answered right now about the FinTech and especially FinTech industry and how, it's already been gearing up with respect to its data regulation policies, etc. So I remember a couple of months ago, I was studying the GDPR because I had certain provisions that I wanted to look through. And I remember thinking while I was studying it that the concept of no implied consent and active consent at every stage, wherever the data will be utilized. I remember thinking from a consumer point of view, it's a very protective mechanism. But for businesses at the same time, especially budding businesses, I would believe it's not very conducive to growth. So, and also it's been speculated now that the DPDP bill, which has been brought forward, is very consent oriented as well. So, do you think for a budding fintech industry or budding fintech companies in India, let's say, will it be conducive for business growth?
Right. Thanks for that question, Yashunandini. So, like I said before, going forward, a fair number of entities, depending upon which business they are in, which could include fintech, could include a host of other things, both at the entity level, at the business level, in terms of what kind of business or industry they're in, or a class of such entities taken together, they may be exempt from a lot of the more onerous obligations under the DPDP Act, in terms of including taking a very explicit, unambiguous consent, right? Which is a higher threshold than what we had before. So, for example, startups have been specifically mentioned, and this is something that, as we know, the government has been very vocal about being startup friendly, because this is the wave of the future and they want more entrepreneurs to emerge. So startups, which are, like you said, budding businesses, right? They are trying to scale up. They're already facing a lot of competition in a particular business. Is it fair to give such an onerous compliance, impose such an onerous compliance burden upon them? No, it doesn't make sense. Let the government notify them as exempt, and they will not be, playing on a level playing field, so to speak. They will be given special allowances. So I think that has been envisaged. How this plays out, we'll have to see. I personally feel that the government has always championed itself as being business friendly. So in case there is a critical mass of concern among a particular category of entities or in a particular business, the government will be acutely responsive to such requirements. How that's going to play out from the individual interest point of view, as data principles, is it going to be a good thing or a bad thing for us? We don't know. But in terms of the commercial interest, I think the government will try to find a balance. So, I mean, what I'm saying is there are mechanisms in place for adjustments to happen. And I think it's highly likely that these adjustments will happen. So entities which anticipate that they need a lot of personal data to make their business grow, but at the same time, these onerous obligations will really hamstring their trajectory, can perhaps relax a little in anticipation that there will be exemptions granted to them. Likely.
All right.
Yeah.
All right. Thank you so much, sir.
Thank you for that. So I think we have Harsh next. He has a question for you.
Yeah.
Good evening, sir. This has
Good
been a great session so far. So you talked about the data flow. So where government had adopted a positive approach where they get to choose what trusted jurisdiction is. But if we talk about the bill of 2022, they had a negative approach where they choose to decide where data cannot be transferred. So my question is there any difference in the logic of legislative entities to structure this provision differently? In the current framework, they had adopted positive approach, but in the previous bill of 2022, they had just a blacklisted of proposition. So is there any differentiation, or it is just an old wine in the new bottle?
No, thanks for the question, Harsh. It's actually the opposite. So there was so unless expressly approved in the 22 draft, you could not transfer. There were restrictions. And now it is a more progressive or more permissive regime that unless expressly prohibited, expressly blacklisted, you cannot transfer, right? Maybe this was your understanding. I heard you wrong, but it is not definitely the same thing. It is the opposite, in fact. It may be tantamount to the same thing in the sense that the government decides which are the countries or territories you can freely transfer data to or not. But why this is widely different is because of, the starting point. So right now, after the act becomes effective, it will take a certain amount of time for countries to be expressly blacklisted, right? That, okay, you cannot transfer data to these countries or territories until someone comes and tells you. So the underlying assumption is that you can transfer data anywhere. As opposed to the previous formulation, the underlying assumption is that you can't transfer data anywhere unless expressly authorized, unless expressly approved. Now it's the opposite. Unless we tell you that you cannot transfer data to country X or territory Y, you can transfer data anywhere. So it's a fillip to cross-border data flows, and India being as integral and pivotal to the global economy, including in particular the global data economy. This was something I think the government wanted to address in this way.
Okay, sir. Thank you, sir.
Thank you, sir. So due to the positive time, I think we have time for just for one more question.
Sure. Yeah.
Yes, sir. We have Tushar with a question, sir. Yes, Tushar.
Hi, sir. Am I audible?
Yeah, you are.
Yeah. Yeah. Hi, sir. So I'm Tushar, fifth year student from LU, sir. So I basically have two questions, sir. First being that, like, if there are violations by an entity under the DPDP Act, that is, if the data processor or data fiduciary violates some of the rights of the data principles, that is, right to erasure, right to be forgotten, different rights. So, sir, I wanted to understand that the powers with the board will be just limited to awarding the penalties to the violators, or will it also extend to giving compensation to the person who has actually been harmed because his or her rights have been violated by the company?
Right. No, that's a great question, Tushar. Thank you for that. There is no compensation mechanism contemplated. So under Section 43A of the IT Act, which was the existing data protection framework in India, as basic as it was, There were some compensatory mechanisms contemplated, right? So if because of the negligence of your data handling, there was some loss or gain wrongfully caused to a person, then you could be compensated. The damages framework did not prove very effective. Implementation was very bad. There was almost nothing that emerged out of this provision. So I think the government took a call to move away from this compensatory damages based framework to move to something of a more deterrence model, whereby financial penalties, at the same time, there is no criminal uh, sanctions contemplated under the DPDP Act, but the quantum of financial penalties contemplated are pretty large. So yes, aggrieved data principles, to come back to your question, Tushar, under the DPDP Act, if my data is leaked, for example, and I find out, and it is actually found that my data was leaked because of the data fiduciary's negligence or because they did not have systems in place, and they could have done something about it, but that they didn't, they will be slapped with perhaps a big penalty. I wouldn't get anything under the DPP Act. However,
then,
I mean, I could take recourse to, other regimes, civil liability and everything else, maybe under tort law or whatever.
wonderful, sir. So, just my second question, sir. As far as I understood, the DPDP Act has an extraterritorial application. That is, it applies also to the processing of data outside India. So, I just
Right.
wanted to understand how would this work? How would an Indian legislation govern companies processing data outside India?
So you know how it is, right? And for the benefit of those who don't, the extraterritorial application is limited to the processing that happens outside India. If it relates to some activities which are offering goods or services to people in India. So the idea is that you are ultimately offering services and goods to people in India. So, this law will apply to you. So, for example, how it will apply in the sense that if it is found that some data processing activity is happening beyond Indian territory, and these services are being offered to people in India, that service can be blocked. That platform can be blocked. The public will be not granted access to such platforms, websites, etc., etc. Whether the same kind of penalty will be imposed upon these foreign entities, we'll have to see. In terms of legality, in terms of practicality, how they can be brought under the regulatory / legal scanner. Having said that, since we are down this rabbit hole, Tushar, I would just like to mention that under the 22 draft bill of the DPDP Act, there was another parameter where extraterritorial application was extended. So if some processing was happening outside Indian territory, but which, concerned with activities which did individual profiling of people in India, the law would apply to these kinds of entities and processing activities as well. That has been taken out from the final act. So what this means is that entities which are outside India, if they are processing personal data of individuals sitting in India, you can profile them as long as you're not offering them any goods or services. So while targeted advertising and stuff like that, or an e-commerce platform, you can't do. But I mean, sorry, the law will apply to you. So you have to take consent, etc., etc. But if you're just profiling them, for example, figure out what their interests are, figure out what their consumer preferences are, etc., etc., you can do that without giving them notice that you're doing that, without informing them that you're doing that, without taking their consent. as long as you're doing this processing outside Indian territory. It seems that this was given as a signal to machine learning platforms, AI developers, because Europe has a new law in place now, whereby these AI developers will also get compromised, will not be able to, rely on publicly available data necessarily willy-nilly and, design their AI training sets. But India may provide a happy hunting ground, at least as far as profiling of individuals is concerned, because this data in itself may be valuable. But you have to conduct the processing outside India.
Understood, sir. Thank you so much for the answers.
Yeah. Thanks, Tushar.
Thank you so much for all the questions, audience. And I think with this, we come to the end of this session. First of all, thank you, Deborshi, sir, for giving your time.
Thanks, Nikhil. Pleasure.
Yes, sir. So I think, so just before we end the session, if we can just quickly take a picture for our internal record purposes. So I'll just be clicking a screenshot if that's fine.
Sure. So this is a notice and consent mechanism happening, right?
We're implementing the DPDP Act after learning it.
Yes. Congratulations.
All right. Thank you, sir, for this collaboration. We look forward to collaborating with you in the future as well. I'll be in touch with you as well. So thank you so much for this, sir. Yeah. Thank you. Thank you, everyone, as well. Thank you for everyone for joining. I hope this was a fruitful session. I will be, the center will be sending across a feedback form to get your feedback on it. And sir, I'll be sharing the feedback with you as well. So maybe we can get to know how the audience exactly found this session as well.
Sure, sure. Thanks, Nikhil.
Thank you so much, everyone. Thank you so much, everyone.
Thank you so much.